Welcome back to Public Contracts Annual Review webcast. We hope you're enjoying the most convenient way to hear expert briefings on the year's most important legal developments impacting government contractors. I'm Fernan LaValle from Jones Day, and the moderator of this third panel on intellectual property, information technology, and cybersecurity. It's my great honor and privilege to have my colleagues on this panel. In the center, Jay DeVecchio of Morrison and Forster, and Peter Meller of Kroll and Mooring. So let's get right to it, gentlemen. The first thing that we would like to talk about this morning in the area of developments in intellectual property, in particular in government contracts, are some of the regulatory changes that we've seen that are important to all contractors at all tiers, but also to the public sector and the government administering these contracts and awarding these contracts. One that we're going to start with is the GSA's final rule on commercial commercial software terms and conditions. We had seen some prior proposed rules and interim rules, but finally in February, GSA issued its final rule, which happily took to account and took to heart a number of the comments from the public sector and from contractors. The rule's purpose is really fourfold: to decrease the amount of time that's spent negotiating contradictory terms and conditions, since most commercial software licenses have similar but not identical requirements, and they don't all necessarily comply perfectly with federal law. The second is to facilitate and improve the review cycle that the government needs in order to look at and appreciate contractors' commercial software licenses when they actually decide to do so. We'll see a case a little bit later this morning, Cyasoft, where the government may not have reviewed those terms and conditions very clearly or carefully. To reduce the administrative burden for contractors in terms of knowing what kinds of terms and conditions will work in your commercial software. And then finally, to try to establish a consistent applicability and understanding of what are acceptable terms and conditions. So to achieve this, the final rule basically implements a deviation GSAR clause, General Services Administrative Regulation Clause, the 552.212-4 clause, which lists essentially 15 terms, 12 of I think the most important here on your slide, that the government will find to be unacceptable or unenforceable, or they rephrase them, frankly, to try to bring them into what they find acceptable. These will apply to all GSA scheduled contracts, all GSA-administered government-wide acquisition contracts, or GWACs, and indefinite delivery, indefinite quantity vehicles that offer products or services that require commercial supplier agreements, no matter what they're called, end-user license terms, terms of service, whatever the name is. I think what's important as a practical point, and Jay, I know you and I have talked about this over time as we help commercial contractors, is one, these won't apply to your non-GSA governed contracts, although typically a contractor can't really have two different sets of customary commercial terms, so you're probably going to come largely in line. Here, though, be careful and really look at the fine print, because some of the clauses would throw out terms that really should not be thrown out. For instance, things like no indemnification. Here, the language has been modified to say except as allowed by statute and agency rules, but that's important. Don't let the government ask you to exclude the clause entirely. But finally, particularly at GSA, often where a software is involved, the GSA would like to include the FAR 52227-19 Commercial Computer Software Clause. If you're going to take the deviation clause, you're going to have to ask them not to include the 52227-19 clause. It is not really a commercial software license. It will act in spite of all other terms and conditions that the government has otherwise agreed to, and it will provide, for instance, as an example of something that commercially is typically not provided to end users, the right to modify or make derivative works from your commercial software. So there's good reason to exclude the -19. It's not mandatory, and frankly, you can point to the guidance in the FAR that says, hey, if the government understands its rights, which it certainly will with the deviation clause, there's really no need to go to the -19 clause. Let's talk about two other changes that are not immediately on the slide. The first is in October, the Air Force Systems Space and Missile Systems Center issued its 9th edition of its Data Right Handbook. I commend that to practitioners both in the government and in the private sector, in the private bar, and contractors, of course. This is a very comprehensive publication. While it certainly tees on the Defense Federal Acquisition Supplement because of the Air Force's being a DoD component, a lot of the rules are universal for federal contracting. So it's a very useful guide even when you're dealing with technical data and software issues with non-DoD entities, and certainly within DoD, non-Air Force components. I also want to mention the Section 813 panel. The final report just came out recently. It addresses specifically technical data and software issues. It's comprised, as we had been told it would, of a number of tension point papers that summarize and address concerns from the public sector standpoint and then from the private sector standpoint. I purposely chose those terms. I avoided saying the industry because while that's the language we see a lot, one of the takeaways from the report is the recognition that just like the government not being a singular monolith that has one approach and one position on these issues, neither is the private sector. Some of the tension point papers even point to some of it has to do with the specific uses or which portion of the industry, for instance, that you sit in. If you're a maintenance provider, obviously the amount of data that you would like to have access to and it would be necessary would be very different than being the manufacturer providing the product in the first instance as two examples. And that's a nice segue, I think, to the slide on the final rules, the NIST final rules implementing the Bayh-Dole Act regulations. The first major update to those rules, probably since the 1980s, certainly early 90s. The Section 813 panel did not have patent rights or subject inventions in its mandate, so it's silent on patent rights. So here we have the NIST update. It certainly does a number of things. One is it updates the regulations to reflect the America Invents Act and to kind of make it consistent with those changes that we've seen in patent law occurring the past several years. But two provisions in particular that I want to point out is one is the government's rights to take title in inventions. This is a right that the clause has always had that allows the government to require forfeiture of a patent as a non-exclusive remedy in three potential scenarios. One is where the grantee or the contractor in a grant that has the standard patent rights clause or in a federal contract that has the standard patent rights clause, the 52-227-11 clause these days. If they either fail to disclose the invention to the federal agency within a reasonable time, the second, if they fail to make a written election to retain title within the prescribed time in the clause, or thirdly, if they fail to file a patent application prior to any statutory bar or foreign applications within a reasonable time. The clause always allowed the government, from the moment it became aware of this, to take action and move for forfeiture. However, the government had to do so within 60 days under the old rules. Now, the time limit has been removed. So this potentially is an open-ended liability or potential risk for contractors. On the flip side, the government has a lot more time to understand when one of these events has occurred and then to act on it. This is not necessarily good news for the mergers and acquisitions aspect, because obviously that's a risk that most acquirers would like to know is bounded. The other component I'd like to point out has to do with the requirement to get a present assignment of rights in a subject invention. Again, that has always been a requirement of the clause. Typically, for-profit contractors address this requirement by including it in the employment agreement with its employees, that they make a present assignment of any rights and patents or subject inventions that they may be involved in inventing. For nonprofit entities, and particularly universities, often the culture is a little different, as well as the leverage that professors or other members of those types of nonprofits would have, the ones who are involved in the research and development. And often the practice has been to obtain the present assignment at the time that you're going to disclose to the government the subject invention. So usually well after employment, and in most instances well after even winning the award of the grant or contract that's subject to the requirement. The clause now, as it reads, is a little bit ambiguous. It just charges that contractors must get the present assignment. What's interesting, though, is that NIST, who of course published the rules and would be the first source to turn to since they enforce the Bayh-Dole regulations, in an informal, frequently asked questions about the Bayh-Dole regulations, they advise contractors that the expectation is that you're going to have the present assignment without respect to whether you're for-profit or nonprofit, essentially at the time of award or shortly thereafter. And the guidance says that that's to ensure that the employee's written obligation to assign to the contractor is clearly established for the entirety of the funding agreement, to best protect the government's interests against any kind of competing claims. So waiting until the time of patent disclosure, NIST says, would not satisfy either the rule nor the purpose of the rule. So a potential point of friction, frankly, for a number of contractors, and may even be an issue broaching a constitutional issue, since the rights of the inventor, of course, are established in the Constitution, and here we have a regulation that is suggesting a required, basically, assignment of that inventor's rights. Like to turn next to a couple of developments that start to bridge to our discussion on cybersecurity. The first is in March of this year, we had a memo on out of the Office of the Secretary of Defense on enhanced Section 806 procedures for supply chain risk management in support of DoD trusted systems and networks. These are essentially systems or networks that are national security related, so primarily secured networks. And it's, again, Section 806 has been in existence at least since the National Defense Authorization Act for 2011. What this memo did, though, is it kind of brought to the forefront and emphasized the procedures and the importance for both DoD and, frankly, the intelligence communities follow this guidance as well, to go ahead and take certain administrative procedures when they have actionable intelligence or intelligence, much of which is not public and in many instances won't even be disclosed in full to the contractor, where there is a suspicion that a particular product or particular contractors or subcontractors pose threats to these trusted systems, to exclude them from the particular access and particular contracts where they might have access or requirements. This is separate from any kind of suspension or debarment activity or other rules. There is a procedure and there is an administrative appeal that's available, but we're seeing some of this done in instance where I'm familiar, happened to be where the contractor had certain Russian investors, for example. Related to that, but separately, not under Section 806, was the rulemaking on the Kaspersky Labs. It went final actually in October, I think. of this year, Kaspersky specifically as a source of supply to the United States government is prohibited under Section 1634 of the National Defense Authorization Act for this year, 2018. And effective October 1st, all executive agencies are forbidden, its department, agency, organization, or other element of the federal government from using any hardware, software, or services that are developed or provided in whole or in part by Kaspersky and any of its corporate successors, any entities controlled by or under common ownership or control with Kaspersky Labs, and any entity in which Kaspersky has majority ownership. We have a new part in the FAR that implements this regulation. I believe it's FAR 4.20. And there's also a new FAR clause that will include this. Again, this is also agnostic as to whether you have a non-commercial or commercial contract. There are reporting requirements. They differ for civilian agencies within 1 business day of identifying a covered article. You are to notify the agency of its existence. At DoD, this is done through an electronic portal in the DIBnet. And then there's prompt timelines to then mitigate and take action on that and report to the government with your follow-up actions. I believe it's 10 business days for providing the initial notification. You're required to have mitigated and taken these actions. And Peter, with that, I'd like to turn to cybersecurity generally and privacy issues and a lot of the activity we've seen this year in that area.
Sure. Thank you, Fern. So in my day-to-day work, I work not only with government contractors, but also with private sector. And for that, 2018 has been really notable because we're seeing a real convergence in legal and regulatory and risk management approaches. And so I thought what I'd do, we've identified some of the key materials in the slides, but I thought what I'd do is take a step back and talk first about some of the common themes that we've seen this year across materials, both in terms of defense and civilian side activities, as well as the private sector. The first is there's definitely an emphasis on an enterprise-wide approach to risk management, both in terms of centralizing and standardizing. And so the days where information security was one part of a silo and privacy was another part of a silo, and then the remaining activities were handled differently, are really falling behind us very quickly, and we're really moving much more to a system where privacy and data security are integrated into day-to-day operations. We've also seen a much deeper dive into security requirements. We used to see standard comply with all applicable security requirements issues without really specifying what constituted reasonable security or adequate security. And increasingly, there's a realization that you need to do more than simply do that. We've seen some of the NIST guidance that has actually talked about what kinds of security need to be accomplished in certain areas. So we see that in 800-171. We're going to have a revised version of the NIST 853 Rev 5 coming out, and that will integrate both the privacy and data security controls and take a much more risk-based approach. NIST has announced that it's going to be developing a privacy framework that's going to mirror the cybersecurity framework. And so all of these are looking at sort of outcome-based, risk-based approaches to how we handle and protect information, not only personal information, but confidential, non-public information. So as we look through that, we're starting to see notions about supply chain and vendor management issues, because there's a real recognition, as we've seen in the private sector, that often the vulnerabilities aren't through the primary contractor, but they're through the decisions the primary contractor makes about who to do business with and how to flow that information down. And so, for example, the MITRE report that came out in October, the Deliver Uncompromised report, really focuses on this. And the, both the DoD cybersecurity guidance as well as the White House security guidance, there's a real focus on supply chain vendor management issues. The other place where we're really starting to see much more focus is on audit and accountability throughout the information lifecycle. One of the challenges that has existed is most folks have had contract terms and it stops there. And there's now a recognition that you have to have a priority-based approach to risks where you continue to make sure that controls are working the way they're supposed to, where your vendors are complying with the requirements, and where you're sure that on a continuous monitoring basis you haven't created gaps or risks that might put you out of compliance with your contractual obligations, whether those contractual obligations are to the federal government, to a state government, or to a private sector entity. So the kinds of questions you see coming up in the audit and accountability space are, how do you know that what you're doing, it works? How do you know that it continues to work? What kinds of enforcement steps are you taking, both inside your organization and outside your organization? And are there incentives in place that can encourage sort of the right kind of approach to this security and risk management? And the MITRE report in particular talks about things like perhaps expanding the Safety Act to recognize cybersecurity and risk measures, creating tax incentives perhaps for companies that comply, allowing costs of compliance to be included in the contract costs under certain circumstances. So things that make this really a business development and pro-competition tool, which is really, I think, the best way to think about security and privacy. So that's what we've seen kind of this year. So I want to talk very briefly about next year. What kinds of things do we expect to happen next year based on what we've seen this year? The first is there continues to be real tension between federal law, state law, and international law in terms of security generally, but very specifically in terms of breach notification standards, and particularly for clients who are in both the government contracts and the commercial space. They may be subject to a huge patchwork of security requirements and notification requirements. And so there is once again a national initiative to develop federal standard breach notifications, perhaps to preempt certain state standards, and perhaps to address the relevance of foreign requirements, including those under GDPR. So we'll have to see how those play out. I mentioned before that NIST 853 Rev 5 is going to be coming out with its risk-based approach, the NIST privacy framework. We'll continue to see more development on the supply chain and vendor management front. The FAR clause regarding CUI is expected to come out. We expect the draft to be out sometime in December. Increasingly, security is going to become an evaluation factor in government contract space, where it can become not only an evaluation criteria, but a selection criteria. The MITRE report talks about the importance of security becoming the fourth pillar, along with the notion of cost and performance and timing. So all of these things are really kind of pushing toward a much more security-aware, risk-aware environment that we talk about. I also think we're going to see a decreased agency willingness to process exceptions. It's already somewhat difficult to convince an agency to depart from a requirement for security, and you end up making an equivalency argument about other controls that you have in place. This year, some of the developments we've seen include a requirement that you have not only SSPs, but also POAMs, and that those SSPs and POAMs also can factor into not only the evaluation factor, but also the compliance factor. And so to the extent an agency decides to ask an entity to comply, to certify its compliance with one or both of those, there's a real emphasis on disclosure and follow-up to make sure that you're actually in compliance with the security requirements. So turning briefly to developments, in addition to what we have on the slide, on Monday of this week, December 10th, OMB issued memo M1903, which addresses cybersecurity at federal agencies, specifically in the context of high-value assets. And high-value assets had previously been defined with a single term. So the new memo expands it to include 3 different components. It can be based on informational value, it can be based on mission essential value, or it can be based on federal civilian enterprise value. So there's a real awareness that high-value assets are particularly critical. You mentioned earlier, Fern, the not contracting with the enemy and being careful about where you acquire information from. And so this is sort of part and parcel of that approach about making sure that high-value assets are protected in a risk-appropriate way. And with that, OMB and DHS take on major roles. There's a requirement for agencies to make sure they have adequate funding. And there's specifically a requirement that it applies to the procurement of information systems, system components, apps, or services that are designated as high-value assets. So it incorporates security, privacy, risk management, and supply chain management, and this is the clear trend that we're seeing from OMB. Separately, on Monday, also, the House Oversight Committee issued 2 reports regarding the Equifax breach. And the majority concluded that the breach was entirely preventable. It identified a lack of accountability in management structure, complex and outdated legacy IT systems, a failure to implement reasonable security, and a lack of preparedness to anticipate the potential of an incident and support affected consumers. And so in that space, the minority issued a report where they essentially criticized the majority for failing to come up with solutions to the problem and offered solutions. It's interesting because the minority is soon to be the majority, and so we can sort of anticipate that this report and the legislation may reflect some of that as we go into the next year. So there were three sort of key recommendations of interest from that minority report. The first was moving to a comprehensive federal notification standard for breaches to replace the sort of state patchwork that we're currently dealing with. The second one was to require any contractor that's providing federal information services to comply with NIST and government contract security standards, which is not currently in place. There's sort of a gap, as you know, between sort of the definition of federal information systems and federal information on the one hand, and contractors and suppliers who touch the federal government in other ways. And I think this is a real recognition consistent with supply chain and vendor management that we need to move in a direction of making sure that everybody who touches federal government and federal government information is complying with the same set of standards. And then the final one was to increase the FTC's enforcement authority by giving it civil penalty authorities. So the FTC's federal enforcement activity was no longer a cost of doing business, but akin to GDPR, had an eye-opening awareness of what could go wrong if there's a problem. We have a little bit of time. I wanted to briefly touch on a couple of the things that we've talked about. In June, NIST came out with 800-171, the first revision for protecting CUI. And in that revision, they had an expanded discussion of the controls, and this is where the requirement to have not only an SSP, but also POAMs in place comes in. And that revision should be read in the context of 800-171A, which came out in February of 2018, about how you assess security requirements. And that document has samples of SSPs and POAMs. It focuses on an increased dive into security throughout the life of the system. It documents the different kinds of CUI types and explains it in more depth. And it requires a detailed narrative of each of the system components. So a real awareness now that everyone needs to know what their system boundaries are and what falls outside those boundaries and is somebody else's responsibility and what falls inside it. And then it also talks about sort of how CUI affects the activities overall of organizations. So with that, there's a long-awaited FAR clause that we're expecting to come out in draft any day now with a comment deadline in February. We expect that it's going to mirror the safeguarding and incident reporting requirements from the DFARS clause that's already in place, 7012. And then we think that it's going to have a ripple effect through 800-171 and the other components of NIST guidance that affect CUI as well. DFARS, there was an FAQ update that came out in April 2018. And again, consistent with the trends that I was talking about earlier, the FAQs that came out talked about the compliance costs for 7012 being reimbursable. That contracts could be read to include POAMs for controls that weren't in place so that you no longer can simply say, we're going to work on it, but you have to actually make the POAMs part of the contract, and that becomes part of the performance base and the self-certification requirement that we talked about in terms of competition factors. And then we talked already about the MITRE report. That's basically a DoD supply chain integrity piece. And the idea there is security becomes the fourth pillar, and you monitor security throughout contract performance, and there are liabilities and consequences. And this is, I think, where potential enforcement activity comes in. We haven't seen a lot of enforcement activity in the security and privacy space specific to government contracts. But one of the ways to really enforce supply chain accountability and vendor management is to start doing that. There's always this tension between sort of the interim effect of having an incident and figuring out how significant that incident is, and that's going to play out over the next probably couple of years. And with that, I think I'll pause and see if there are any comments, and if not, we can move on.
Something that struck me, Peter, first when you were talking about this week on the Hill, the activity there in the minorities' recommendations. It seems to me that for the first two recommendations, rapid reporting and consistent requirements for reporting, as well as complying with some of the NIST publications, in particular Special Publication 800-171, that those are already requirements, certainly for all DoD contractors. While right now, as you mentioned, the civilian clause that's out there only has 15 basic controls, doesn't quite approach and doesn't invoke the 800-171 or even 853, that we think that the civilian agencies will be fully there in the clause we expect to see in shortly. So in that sense, government contractors are on the front end. I guess we'll have to wait and see if the FTC does get some additional enforcement and how that will play and factor into the already heavily regulated and oversighted government contractors. So there's been a lot of activity in the cybersecurity. We're on the front end of it. Looks like that trend's going to continue. But there's also been a lot of activity in the case law developments, particular to information technology and intellectual property in government contracts. And Jay, I want to turn to that. One thing that struck me this year is that we're seeing this case law activity in pretty much all of the fora that are available to government contractors. Certainly the Government Accountability Office, we'll talk about a few decisions out of there, some decisions out of the Court of Federal Claims that at least have some bearing on rights and technical data, for instance. And then we see the Court of Appeals, the Court of Appeals for the Federal Circuit, with the Palantir decision, for example, but also the Armed Services Board of Contract Appeals with an interesting decision as well. So I'll start it off with Arxiom. Arxiom started as a GAO protest in June of 2017. Arxiom had won an award from the Defense Logistics Agency for the purchase of 4 automated pharmacy systems on behalf of the United States Air Force. Each system would be installed in a different location. These systems are used to very efficiently and effectively fill prescriptions of all types in high volume settings. So DoD hospitals, very large medical installations and things like that. These are commercial items because they're used for the exact same purposes, essentially in the same form in the private sector as well, in pure commercial settings by the CVSs and other pharmacies of the world. Arxiom won the original award, and it was protested by Innovation Associates, and on a number of grounds, but one of which was that these systems were replacing incumbent systems that belonged to Innovation Associates, and that they had compiled a library of first fill prescription images that are necessary for safety checks and other purposes in the process to have available and be able to be called. And Innovation pointed out that it used their proprietary commercial software and that the database was generally not available elsewhere. There were some other issues, including a specific configuration of totes that the medicines move through the automated system on, and things like that. The GAO ruled in favor of Innovation, unseating Arxiom's award, well, recommending that DLA go back, look at its requirements, see if in fact there were ways that they could address this, or if in fact this was sole source, and if that's the case, to take that action. Arxiom filed a bid protest in the Court of Federal Claims, challenging the GAO decision as well as the decision by DLA in subsequent action of implementing the GAO guidance of finding Arxiom to be excluded from the competitive range for the systems that just months before the government had rated as the best for the purposes at a reasonable price, lowest price actually. The reason I want to point out this case is it's a really good example for agencies and not just contractors about this issue that DoD originally had teed up, and that's the vendor lock concept, and setting up an incumbent contractor into a situation where the government has to go back to him. In this case, the original awards to innovation included the appropriate DFARS rights in commercial technical data, which is what the images of the first fill prescriptions would be. I'm glossing over some of the facts. Was that originally the government believed that those images could be pulled from a government database that the government had full rights in. They later found out, and this was what led to and was central in the Court of Federal Claims action, that the government realized that the only source for these first fill images were from Innovation's software, but that the government had not exercised its rights to take delivery, even though they even had, we believe, deferred delivery, deferred ordering clauses in the original commercial item contract. Of whatever reason, time had passed or something, the government had not exercised those rights. Now the first fill prescriptions were only available from the incumbent contractor. It was a necessary requirement that the government wouldn't relax. ArcSium attempted to obtain a license to use those images, at least for the time that they needed before they were generating their own, and the incumbent declined to deal with them. And so ultimately, the court found that the GAO's decision was unreasonable. It had not taken into account and had not fairly addressed the solicitation requirements and how the action the government had taken. They also entered a permanent injunction against the award of a new contract until DLA and the Air Force had gone back, looked at their requirements, revised their proposal, and put it back out. The court was prescient, though, because it said it's possible that the agency may come back with either a sole source or they may revise the procurement and in a manner that may make it impossible for ArcSium to compete, basically preclude them from offering. The agency revised solicitations. ArcSium again reevaluated and tried to put together a proposal, and in doing so realized that the revised RFP still required these same images from that only one source without providing any government license access, and so they were precluded from competition. So judgment was entered in favor of ArcSium, but the not so satisfying remedy of really just getting their bid and proposal costs. Vendor lock issue, agencies, a good lesson in what not to do, actually exercise delivery rights in commercial data if it's going to be important downstream, or else you're going to find yourself stuck with your incumbent again. But Sikorsky is a little different.
Why don't you flip that slide so we can see the Sikorsky case?
I will.
Sikorsky is another example of the GAOs getting involved in data rights issues, which they used to do a lot of and now they're doing more. But the background for Sikorsky is important for contractors because what Sikorsky represents is the confluence of three factors that we see across the board with DoD particularly. And that is the focus on the government now on modular open systems approach, or MOSA, where the government wants to be able to take Fern's system and then later swap Peter's in for it, which means they have to have certain rights and data and access to data that is broader than they previously thought they had. In fact, this is an increasing issue across the government and in Congress, where the government is trying to get more data rights. We see that also in the increase in solicitations, where the government is including as an evaluation factor the ability of a contractor to give a priced option to relinquish its limited or restricted rights to give the government unlimited or government purpose rights as a positive evaluation factor. And then we also see agencies creating more often these unique clauses, query whether they're actually properly promulgated, that impose difficult requirements on contractors and particularly primes because they want the prime to relinquish certain rights and they require the prime to get information from all of its subs and relinquish rights there. Sikorsky is a great example of this. In Sikorsky, there was an omit clause, and that's operations, maintenance, installation, and training. And the omit clause in the Sikorsky contract was one that the Air Force has been using in a number of large procurements. We saw it in the TX trainer procurement, where they said, okay, we're going to get rights and delivery in omit. Omit means, for these purposes, rights in computer software, which sort of got people's attention because software isn't something which under the regulations the government gets OMIT rights in. OMIT is something the government acquires with unlimited rights. It never has that right in software. It also doesn't get the rights, OMIT rights, in detailed manufacturing and process data. Yet the Air Force clause said, well, we need sufficient data to reprocure the items or to manufacture the items, which necessarily implicated OMIT. So Sikorsky challenged this. Interestingly, as they were raising the challenge in the agency realized that they had overstepped their bounds and backed up and said, oh, no, we don't really want computer software and we don't really want detailed manufacturing and process data, which is important because it took the wind out of Sikorsky's principal arguments that the clause was invalid as contrary to regulation, which it clearly was. And that left a debate about what the contractor had to deliver. And what the GAO did was actually recognize something that a lot of companies don't recognize and a lot of government personnel don't recognize, and that is the data rights clauses don't say anything about delivery. And people get confused about this all the time. They think the clause not only describes the license rights the government gets, but also those things in which it gets the license rights, that is the software or the technical data. The clauses don't do that. The analogy I make is if you had the CAS clause in your contract or a government property clause and the government turned to you and say, hey, under the government property clause, deliver me your source code, you'd say, what are you talking about? That's got nothing to do with this clause. Same thing with the data rights clause. The data rights clauses don't say a word about delivery. And the GAO recognized it. And what they said was, well, an agency like the Air Force can specify things to be delivered as OMIT. They can require you to deliver software. They can require you to deliver detailed manufacturing and process data. What they cannot do is to get broad rights in that. You're entitled to assert your normal rights, whether it's limited rights or restricted rights and those things. And that was an important distinction they drew and a good lesson for industry. It's also reflected, these principles are reflected in the VT Halter Marine case, another GAO decision. Remember, I said that what the agencies are often doing now in solicitations is asking you to give a priced option, to give up your rights. In this case, that's what the agency had done. The successful awardee had its evaluation increased favorably as a result of agreeing to give the government unlimited rights. It was challenged by Halter Marine. The GAO said, no, that's perfectly appropriate. That's consistent with the statute being one that precludes the government from holding against you your failure to give up rights as an award criterion, but it's okay if they evaluate you more favorably.
Yeah, it's interesting, Jay. It strikes me in Sikorsky, as you said, we got a nice, cleaner articulation of the difference between delivery, for instance, and license rights and appropriate practices there. But it's really not new law, right? It's an interpretation of the regs and how practitioners have long thought they're supposed to operate, even though the law wasn't, there wasn't a decision out there necessarily that clearly laid it out. VT Halter, similar, no new law or new ground, although perhaps a decision that says the agency can get closer to that line in terms of requiring or heavily inducing the surrender of rights in intellectual property, the private intellectual property.
Yeah, and that case was particularly irksome because I've always thought that if they evaluate you more favorably or they evaluate you downward, it's sides of the same coin. They can't do that. I had happened to represent the company and defended the award, so I was on the side of the government in that case, which I still lose sleep over, but it was the right result.
I understand. Now I'm going to move to CyberSecurity. We only have about 7 minutes left. But Jay, that's an interesting case. This is the one that's out of the Armed Services Board of Contract Appeal and involved translation software being used by troops in combat zones.
Right. And this is one that addresses an issue that had been addressed in the district courts under the non-commercial regulations. And the idea, in one district court decision at least, is that, well, if you have a supplier that is giving software to the government and it is putting constraints on the government, but the contracting officer has never agreed to them, they're not enforceable against the government. That was the opposite conclusion that the board reached in CSOF. There, the contractor had shipped 20 compact disks to the Army for use in Afghanistan with restrictions on how many could be used. The agency ignored the restrictions, and the contracting officer said, well, I never signed up to this deal. I never signed up to this agreement. And the board said, wait a minute, in this commercial context, purely commercial context, not non-commercial software, the government's bound by the terms of the contract, even though it's neither negotiated nor seen those terms, because when you hit the click wrap or hit the shrink wrap, it's assumed that you're engaging in your implied duty of good faith to pay attention to what it is you're signing up to. And the board said, sorry, you have violated the contract. And it has now been remanded, and CSoft is going to further before the board to litigate damages now.
Now, this isn't purely a shrink wrap or click wrap case, though, because in this case, the contractor had actually provided, in addition, hard copies with each disk of the license, and also had submitted the license and negotiated to modify their customary commercial license to meet a specific Army use, for instance, not requiring internet connectivity and that kind of thing. So in that sense, again, not new law, but kind of laying out that the government will be held responsible to meet commercial licenses and abide by them when those commercial licenses themselves meet federal law and the agency's needs.
We'll see how that shakes out when it stacks up against the non-commercial regulations that suggest that the government does have that right.
We're going to have to move quickly. I want to mention on the Boeing case, this one is interesting for a number of reasons. The first is it's not under a procurement contract. The underlying agreement was a technology investment agreement, which is a form of other transaction agreement, which is all the rave now, and which is not subject to the FAR or DFARS or procurement laws with respect to the allocation of rights and IP. Although they do use by default the patent rights by dual type allocation without mandatory flow down and that kind of thing. There is the February 2017 guidance for use of OTAs that suggests that agencies should think about using the FAR and DFARS clauses, particularly if there's going to be follow-on procurements acquiring it, which is sort of an anathema to the idea of the other transaction, it seems to me. But in Boeing's case, they had developed software for the Army under the performance of the TIA. However, when they later went to assert their restricted rights, the government argued that, well, this was developed under a procurement contract. It was charged to a government contract. But when asked which contract, the government agreed it was the TIA. And the board found that, well, no, you use the right test wherever the cost, the development cost charged to, because it was not at the point considered commercial software. But a TIA is not a funding agreement for that purpose, so the contractor could. An important decision and a good one, particularly if the use of OTAs is on the rise. Because of time, I just want to mention the Palantir decision out of the Court of Appeals for the Federal Circuit. This is a great decision. It involved commercial software, great for contractors, but for the government as well, because it's finally a court saying that there really is a statutory preference for commercial items, and that the government has to be diligent in investigating whether or not there are commercial items available to meet its needs. On the appeal, the government had sought to overturn the federal claims court's decision by saying that the requirement to fully investigate the availability of commercial items seemed to exceed what the statutory requirement actually was, and that in fact the market research that the government had done was sufficient in the case. The Court of Appeals disagreed. There was a lot of information about the commercial availability for a system that worked with what the Army was calling the Distributed Common Ground System. I think they pronounce it the DCIGS program. They had acquired the first part of that for billions of dollars in many, many years, and this was the second piece of it. And again, it looked like the government was looking at non-commercial solutions when Palantir proposed that they had something that would fit and do right away. So an important decision. That kind of leaves us a minute, unfortunately, but I know, Jay, you wanted to mention some things about the National Defense Authorization Act.
Yeah, there were a couple of sections in the NDAA that got people's attention, one of which is 866, where they have changed the ability of the government to challenge your data rights assertion. It used to be that the government had to show that there were urgent and compelling circumstances to override a finding that you had asserted limited or restricted rights. They've changed that to say now it is compelling mission readiness requirements. And the question is, what does that mean? Is it really a difference from what was done before and what wasn't, what is being done now? And the answer is it isn't clear. I think that it's not a significant change. A lot of people said, well, they've changed the wording. They're going to do something more and give us more likelihood of overriding. I don't think it's going to happen. That, to me, was the most significant change that came out of the NDAA. And you can see on your slides other issues as well. I don't think we have time to get into them in the last 20 seconds here.
And we'll be seeing more and hearing more about all of that in the coming months. I want to thank you, Jay, Peter, for a terrific panel and for so clearly covering these critical issues in intellectual property, information technology, and cybersecurity. We're now going to take a short 10-minute break, and we hope that all of you will join us for our next panel, which will be on industry trends, beginning at noon, 12 o'clock Eastern Standard Time. Thank you so much.
Thank you.